All right, this is a big part of it, and I get asked this question a lot. It's like, well, do we need to show every single transfer? For example, I get W-2 deposits into my checking account, and every month I transfer it to my brokerage account. Do I need to document every single thing and track that in the narrative? My answer is no, we do not. And I think that's unhelpful. What you want to explain is a coherent, consistent, credible narrative that explains to USCIS how this money was earned and what the investor or the spouse or the family member, how they move that money around. And then we provide the bank statements. But I don't like getting incredibly detailed in like, on this date, he transferred $2,000 from this checking account to this brokerage account. I don't think that's necessary to go into that level of detail. However, if we do see big credits coming into accounts, then there is the chance of commingling. Well, you had money come into this account, but there's also other credits coming into that account. Which money are you using for the EB-5 investment? USCIS says, show me the source of funds for both. And so if we see big credits coming into accounts, we either try to avoid those accounts or we need to explain and or document what those credits relate to, because they will pick on that. Vivian, you have dealt with this a little bit more than I have, I think, but maybe you can explain like what we say on this bottom bullet point about, like DS-160s, like what are they checking?
I just wanted to add one thing to the bank statements. Usually we provide 6-month to 12-month bank statements to show accumulation of the fund before making the investment. If in those 6-month or 12-month period you have large deposit in your account, I don't have a specific number that you should watch for. Like if you have a $2,000 deposit, you should explain it. But if you have $2,000, that amount has been regularly deposited in your bank account on a monthly basis, for example, the USCIS will notice it. So, for example, in one of my cases, the client, his roommate pays the half of the rent every month to his bank account. So the USCIS has been asking what kind of money is that. So we provided the lease and whatever, and then he got zero payments from friends who, for dinner and whatever. So they need to explain that. And for the last point, I want to added more details on the last point, information submitted in previous U.S. non-immigrant visa applications. So these days, any inconsistencies between information submitted in any U.S. visa, non-immigrant U.S. visa application and the EB-5 526 petition can trigger a massive catch-all RFE or NOID. And in these kind of RFE and NOID, they will ask for everything. It looks like the government has like issues with the credibility of the petitioner. So they would ask for information on the applicants and the family members' employment history, income, tax records, and company ownership. They will also ask for information on whether their company has been ever sanctioned by the U.S. government or if they are members of the Communist Party. All types of questions, either source of funds related or national security related. And sometimes they even request information from family members who were not included in the 526 petition or who did not contribute funds to the EB-5 investment. In a recent case, one of the REs of my case asked for the applicant's father who previously filed a political asylum in the U.S., but the applicant herself was not even included in her father's application. And in another case, the RFE asked about the applicant's prior E2 business and how she managed that E2 business, because they suspected that she did not actually in person involved in the day-to-day management of the E2 business, but the source of funds has nothing to do with the E2, and the applicant is no longer on E2 status. So that's how far they can get from the EB-5 RFE to this person's general immigration history and all the previous visa records.
Right. Right. And it is a fair amount of work putting a source of funds brief together. And it is why sort of that first part of getting your EB-5 case is so important, because it takes a little bit more time than I think people realize. Here's a good question, Vivian. Let's say you get a denial after an RFE or annoyed. Is that the end of the discussion, or are you allowed to apply again with that investment that's now locked into the RC?
No, you can reapply. There's a question of filing a new 526 versus filing a motion to reopen. My feeling is that if the denial was like very straightforward and, this is apparent error by the government, you probably want to, and, and the project has prior approvals already, you probably want to file just a new application, a 526, so it can get adjudicated fairly quickly. But if the client has an aging out child and they want to keep the priority date, then filing a motion to reopen is probably the best option. I would usually prefer filing a new petition than filing a motion to reopen, because there's no published average processing time for a motion to reopen. It means that you cannot filing any inquiries with the USCIS if the motion to reopen has been pending for a long time. And, instead, for 526, you can submit inquiries if the case has been pending for quite a long time, or you can go with mandamus. We have had a lot of success with mandamus cases lately. So filing a new petition is usually my way to go, especially when there's no visa backlog at this time.
Yeah, I mean, and if it's, I'm presuming in this question that the money from the initial application was already made available to the JCE, and it would need to be a new investment, because if it's the same money, that's the same issues that are going to come up unless you have different evidence to show why the money was now lawfully obtained after USCIS said it wasn't. So it's not like you're necessarily getting the money back just because the initial I-526 has been denied. All right. So here's a clarifying question. So do we only use the past 6 months of statements, or are we providing 7 years of statements? So it's 7 years of tax returns.
Tax returns, yeah.
Is in statements relates to accumulation of funds, and that I think depends on how much you're saving and when you earn it. It could be a lot more than 6 months. It depends on when the money was earned. It's very fact dependent. Here's a good question. Does investing with crypto complicate establishing source of funds or trigger enhanced scrutiny? I got my thoughts, but Vivian, do you want to take this one? Or if not, I can.
Yeah, we've had success with filing Bitcoin as the source of funds. It depends on what kind of platform you're using to trade those type of cryptocurrency. If it's sort of like a stock account where you can trace and shows your ownership of the Bitcoin, the currency, you can use those as for EB-5 purposes, but it hides everything. It doesn't show the name of the owner, or it doesn't show the transactions or the time and dates you sold those currencies and where you sold it, how much you sold it for. Then you should probably avoid using those type of source of funds for EB-5 purposes.
Right. I kind of think about, and I'm not a big crypto guy, so I apologize if I sound foolish here. But like if it's on a platform like Coinbase and you're using a wallet that is like attached to some system, and it's almost just like an E-Trade account or something like that, and you show you purchased some Ethereum and then it went up and then you sold it and then the money came out, that isn't a problem. I haven't seen that. But yes, you would still need to show proof of funds used to purchase the crypto. 100%. Yes, that is 100%.
And also ownership, because some account just does not show the owner's names. Everything is encrypted. Is that the word?
Encrypted. Yeah, well, like on a Coinbase, for example, it definitely says like the account name holder and has their information. And a lot of times that's included in the tax returns as well. So it's all consistent. But I think that is key. All right, so let's move on. This one is like the true owner of the funds. This to me gets to a couple of issues. One, let's say that you are getting a loan, you're a student, your father, you're not able to find an H-1B employer, or if you are, you're not selected in the lottery, you're done with OPT or STEM OPT, your father loans you money, and you invest that money. So ideally, I would love to see the money go into the investor's individual account. That's ideal, and the investor makes the fund transfer to the NCE from that account. There have also been cases where USCIS has accepted where the lender or the giftor invests the money for the benefit of the principal investor, and USCIS has historically accepted that as well. Now the question becomes as well, is that money controlled by them? Is that the true owner? Do they have unrestricted access to those funds? And when they talk about those types of questions, I think you're really talking about title to the actual asset. And you want to make sure that in the loan agreement, there's language that says when exactly title is being transferred. It's transferred upon execution. And now the borrower is directing the lender to transfer the money to this NCE account at the borrower's direction, right? So there's things that you can kind of do in the loan agreement to make sure that it's very clear that, yes, the investor is the true owner of the funds. Obviously, the subscription agreement and everything like that would be in the name of the investor as well. Okay. The other thing that I wanted to mention here relates to this concept of a self-directed IRA. And we have a couple of questions on that, and it's something that has been popping up. And USCIS adjudication policy has changed on this a little bit as too. So the way that a self-directed IRA works is you have like funds in a 401k from a prior employer, or you have funds in a Roth IRA, and they're invested in certain assets. Well, what an SD IRA is, you sort of sell the assets, but they maintain in the IRA account. You transfer the custodianship of that account from the existing to a new custodian who then invests it through the IRA into the NCE. And this is a new thing that has been picking up over, I would say, the last 18 months. USCIS has approved these cases. I've gotten a number of them approved. Recently, there have been some RFEs or some notices of intent to deny that USCIS has issued related to this issue. So is it still accepted? Yes, projects are still accepting it. Is there additional immigration risk? Possibly. What are the RFE and the NOID asking about? Well, they want to make sure that the trustee or the custodian is licensed to do it. They want to make sure that if that they're registered either as a bank or on this non-bank trustee list, which is on the IRS website. But really it kind of comes down to this issue of like ownership is the funds, are these funds lawfully obtained? Well, clearly they were obtained from the 401k from the old employer. But are they the true owner of the funds? Well, the investor is a beneficial owner. The custodian is technically the legal owner. Is USCIS going to be picking on that issue? They haven't to date. Could they in the future? Yeah, I guess they could. I haven't seen them do that. That has not been in the RFEs that I have seen so far. And the other thing that I would say is that when you're using an SDIRA, it is one membership unit that you personally own. It is just being funded by separate accounts. And the way that I've seen it is that the NCE will then issue K1s to the investor individually, as well as to the custodian account, the custodian self-directed IRA. So rather than getting one K1, they're getting two K1s for for K1 purposes.